All right, today we're diving into the Romanian disciplinary procedure. Now, for employers, this isn't just a set of guidelines. Honestly, it's more like a legal minefield where one tiny misstep can end up costing you big time. So, let's break down exactly how to navigate it safely. Here's how we're going to tackle this. First, we'll look at why the stakes are so high, what we're calling the costly legal maze. Then, we'll walk through the 7 mandatory steps you absolutely have to follow. We'll also pinpoint the most common traps employers fall into, explore the employee's right to defense, and then wrap it all up with a final compliance checklist to keep you out of trouble. So, here's the big question that drives a lot of employers crazy. Let's say an employee has clearly done something wrong. You've got the proof, you apply a sanction that seems totally fair, and yet it gets thrown out in court. How on earth is that possible, and why does this seem to happen all the time in Romania? Well, the answer is actually pretty simple, but it's absolutely crucial. In the Romanian legal system, the way you do things, the procedure, is every bit as important as what the employee actually did wrong. You could have an open and shut case, but if your process has even a tiny flaw, the whole thing just crumbles. That's the #1 rule you have to remember. And that brings us right into our first section. You really have to think of this whole thing as a high-stakes legal maze. Getting it right isn't just about best practice. It's about protecting your company from some seriously painful financial and legal consequences. And this quote really says it all. The courts in Romania are not kidding around about this. They will put your paperwork and your process under a microscope before they even begin to look at the evidence of what the employee did. The how literally comes before the what. And if you fail that procedural check, well, here's what you're looking at. The court cancels the sanction. You'll probably have to reinstate the employee. Oh, and you could be on the hook for back pay, damages, plus all the legal fees from a long, expensive court battle. The stakes are just incredibly high. So how do you avoid that absolute nightmare scenario? Simple. You follow the map. This next section lays out the 7 mandatory steps that will guide you safely through this entire process, from the very beginning to the very end. Okay, let's break down the first 4 steps. First, you identify what happened, but then comes the most critical part. Number 2, you must conduct a preliminary investigation. This isn't optional. It starts with a formal written summons to the employee. If you skip this step, your case is dead on arrival. It's an automatic nullity. After that, you hold a hearing and then evaluate all the evidence. Now, for the final 3 steps. Once the investigation is done, you apply a sanction that actually fits the offense. It has to be proportionate. Then you draft the official, formal decision, and finally, you have to deliver it within a very tight 5 calendar day window. And that written decision we just mentioned, it's not just a letter. It's a formal legal document, and it absolutely must have these 5 specific things in it. I mean it. If you miss even one of these, like forgetting to mention the employee's right to appeal, a court can and likely will throw out your entire case. This leads us perfectly into our next section. Where do most employers actually mess this up? Because, look, knowing the steps is one thing, but knowing where the banana peels are is how you avoid slipping. And the biggest trap of all is timing. You have 2 deadlines that are completely non-negotiable. First, you have 30 days to issue the sanction from the moment you found out about the misconduct. And second, you can't apply any sanction later than 6 months after the act actually happened. These aren't suggestions, they're hard stops. So here they are, the greatest hits of procedural mistakes. Skipping that preliminary investigation? It's an automatic loss. Missing those 30-day or 6-month deadlines? Your case is over. Sending out an incomplete decision letter? You just handed the employee's lawyer a winning argument. And trying to build a case on weak, undocumented evidence? It's just never going to hold up. You know, to really master this whole process, you need to understand the why behind all these strict rules. And it all boils down to one fundamental principle: protecting the employee's right to a fair defense. That's the bedrock of this entire system. And to see that in action, let's just quickly clarify something really important. A disciplinary dismissal is because an employee is at fault for something. A redundancy dismissal is for economic or business reasons. See the difference? One is an accusation of wrongdoing, and that's precisely why it requires that whole mandatory investigation. The legal bar is just so much higher when you're claiming someone is at fault. And these are the rights that the entire procedure is built to protect. The employee has a right to know exactly what they're accused of. They get a real chance to defend themselves with evidence and witnesses. They can bring a lawyer, and they always have the right to challenge your decision in court. Honoring these rights isn't just a good idea, it's the law. Okay, we've covered the what, the how, and the why, so now let's pull all of this together into a simple, final compliance checklist that you can literally use every single time. Seriously, think of this as your pre-flight check before you take any action. Just go right down the list. Did we do the investigation? Check. Did we give the employee a real chance to be heard? Check. Is every piece of evidence documented and are we inside the deadlines? Check. And does our final decision letter have all 5 of those mandatory parts? Check. Only when you can say yes to every single one of these should you even think about moving forward. Because at the end of the day, it all boils down to this. The hard work you put in before you even start the official procedure is what will save you from a world of financial pain and legal headaches later on. Being proactive is your absolute best defense. So I'll leave you with this final thought. Don't just ask if your process is working for you. The real question you need to ask is this: is our process built to survive the intense scrutiny of a legal challenge? Because in Romania, that is the only question that truly matters.